getting litigation experience along the way. So again, that's Thursday, the 8th, from noon to 1. Jared, did you have anything to add about that?
No.
Marcy, that's actually a program I run.
Oh, here we go.
So if you have
a great segue.
If you have questions about it, you can ask me.
Okay, so let's turn it over to Monique, and now we're going to get.
Just turn it on. That's probably safe.
So I think this. Let's just have you go. It might be my mic interfering with your mic.
Okay. Should I turn it back on, or should I just yell?
It doesn't. Here, why don't you take this? Pardon the technological problem.
I can project. Just tell me if you can.
Just a trial or.
Yeah, I can project. So let's see. My start. I had 3 years between college and law school, and I worked in a nonprofit background. So I was working in the areas of civil rights, homeless advocacy, and immigration all before law school. So by the time I got to law school, I had a pretty good sense of what I wanted to do. I knew that I would do plaintiff side work, and I knew by that point I had actually done some criminal defense work as a non-lawyer with a criminal defense attorney, and then when I was in law school, I actually worked on a death penalty appeal. So I knew that I didn't want to do the criminal side sort of day to day. Although I've continued to do criminal appellate work, I've done a couple of death penalty appeals. I did, and this is a plug for clinics. I went to Davis, and one of the reasons I went to Davis is because they have a great clinical program like Colgate does, and it was absolutely critical to my experience because I'm a person who learns by doing, and I really needed to kind of get in and see what a case looked like and how to really provide access to justice for people. So I did the Civil Rights Clinic my 3rd year, and I actually ended up doing a jury trial as a certified law student in the Eastern District, which was a really unique and fabulous experience. And after that trial, in which the judge gave me and my co-counsel an A+, which is very nice on the record, and I have the transcript. My professor at the time she was an attorney who was also connected to the pro bono project related to the federal court system, where they connect attorneys who are willing to do pro bono work typically on behalf of prisoners, but it's pro se litigants. And she was connected to somebody here. So the story here is, get to know a lot of lawyers in your networking. And the attorney here in the Bay Area was a solo civil rights attorney who was looking for an associate attorney. He had never hired somebody right out of law school, so I had to really convince him that I was worth the risk. And I ultimately ended up staying in his practice for 6 years. I have always had an interest in employment work, and my 2nd year of law school, before I did this civil rights trial, I was an intern at the Employment Law Center here in the city, which is part of the Legal Aid Society, and it basically is the Legal Aid Society. And I did their workers' rights clinic, and I also worked on a couple of litigation matters with a few of the attorneys there. So I knew that I really liked the idea of doing employment work, and because Devin was saying, jobs are a vital part of our existence, and it's really important to make sure that you have access to a job that has the benefits that a state like California has a lot of worker protections, and that job provides those benefits to you. So in my practice with Amitai, my first 5 or 6 years, we did a variety of civil rights work, which included employment. So I did employment discrimination cases, I did some gender discrimination and race discrimination work, I did some criminal appeals, I did some civil rights cases on behalf of prisoners. I had a case involving a Jewish prisoner that wasn't getting access to a kosher diet. That was a case that I did the appellate briefing and oral argument at the 9th Circuit. And that was a pro bono case that we took on from the 9th Circuit panel. So I worked with him. It was a very small practice. It was, at the time, when I first started, I think there were just 2, basically his practice is him, and then he typically has 2 associates. And so great place to start my practice, because it's a very controlled environment. He's very reasonable in the practice. It wasn't crazy. We always had like a kind of a nice number of cases. Litigation, by its nature, is a little crazy because it's driven by deadlines, and can't necessarily help the fact that you might have 3 or 4 briefs due in a 2-week span. But for what it was, I think it was a really great learning experience. A lot of research and writing. Got a lot of experience that I think my peers working for larger firms didn't get in their first few years of practice, because there was nobody else to go to the hearing. It was either me or my boss, and a lot of times he was busy or didn't, or really wanted me to get the experience. So while I was with him, I did several appellate arguments. I argued MSJ, so summary judgment motions, my first year out of law school, so really pretty critical dispositive motions. And that was a really great experience. Then I took a year off, which is great, which I recommend if you can do it. And I traveled, and so I left that practice and took a year off. And then when I came back, I got connected with Jim Sturdivant, which is where I spent the next 6 years of my practice. And Jim, like my former boss, has a pretty small practice. He has a national reputation. He's a legal aid lawyer. He's been around for a really long time. He's a legal aid lawyer on the East Coast, and then moved to California, started this practice here, his private practice here, and it's all plaintiff side, mostly consumer class action work, and so a lot of financial services stuff. So I basically sued banks for 5 or 6 years. So the big part of my practice was doing these big financial services cases where we would sue banks on behalf of credit card holders, bank account holders, and a lot of misrepresentation, false advertising, predatory lending, those types of cases. So that was a big part of my practice, but because I had this strong interest in employment, I started to bring employment cases into that firm. So I started to do plaintiff side wage and hour class cases, and also some more class cases on the discrimination side, both employment and general civil rights cases, like the Title IX case that I did. And then a year ago, I was managing attorney at Jim's firm for a few years, and I left to join my current partners. And we have a small plaintiff side practice with 4 partners. And my partners do mostly individual employment issues, and they kind of all have different specialties. So Noah Lebowitz focuses on disability, and he does a lot of disability leave cases, some discrimination, some harassment, a lot of pregnancy leave and disability leave cases. And then Mark Peters and Tom Duckworth both do more wage and hour, and Tom actually does some employer side work as well, particularly in the advising capacity. So in the past year, I've actually taken some of that on, and I've done a couple of workplace investigations, which have been really interesting to be on the employer side of things, not in a litigation context, but in an advising context. I also I'm still doing a lot of class work, so civil rights and wage and hour class cases, and still some consumer, but I also do more individual employment cases now, which I like. I like having the variation in my practice. What the individual practice gives me that the class cases don't is really regular contact with one client trying to get one result. Class cases are a little bit, they're great because they can have a really wide impact, but if you're sort of not as directly in touch with someone and someone's like need on a daily basis in the same way that you are with an individual. So I have some wage and hour, some employment discrimination, and then I also I negotiate severance agreements for individual employees who are leaving or being asked to leave a job, and that's kind of a variety of hourly work. So I have, in some ways, I've become a little bit more of a generalist than I had been in the past. Part of that is being my own boss and sort of wanting to have a little bit more of a varied base for my practice financially. I would also say that being my own boss in a small firm has really changed my outlook on what practicing law is like, because I'm still a lawyer, still spend a lot of time practicing law. I don't work 9 to 5, but I do have a lot of flexibility in my schedule. So being my own boss does have some really great advantages. I can go in when I want, I leave when I want. I have a really different schedule than my partners do, and I do make sure that I carve out time to do the things in my life that are important to me. But I'm also a business owner, and so that perspective has been really interesting, and I've learned a lot about that, and it's something that I think you all should be thinking about in terms of your practices, because it's just a whole other aspect that I don't think you really learn in law school. So.
Let me ask, does anyone have a question before I ask mine? Can you take a minute to talk about what it was like to be a managing partner in a firm that wasn't yours, where you were you were a partner there? Or
yeah, I was the managing attorney, so I was not an equity partner, but I did basically manage the firm. So we had a staff of, including associate attorneys, of 10 including me. But it's a solo. I mean, the firm is owned and run just by Jim, and so it was interesting. I think it was a great opportunity for me in a couple of different ways. I learned the business side of practice, which has helped me enormously in running my own practice now, both in things I do and things I wouldn't do or don't do that I did while I was managing someone else's firm. I got a sense of what it looked like financially, what the books looked like, which was great. I had a lot of opportunity to supervise and hire and terminate people and deal with benefits issues, and so I learned a lot about the business end of things, and I think this may be somewhat unique to plaintiffs' lawyers, but case selection is really critical to survival, and so seeing how Jim did it and the choices that he and I would make together to bring cases into the firm versus the kinds of choices I make now, they're different. They're different factors, and it's also his practice just looks really different. He does these cases that are huge consumer cases. Does that mean?
I think it's your hair.
It's my hair. Oh, it's very, very noisy hair. When you do consumer class actions, then, and all plaintiffs' practices are really different, and I think this was an opportunity to learn that as well. How plaintiffs' practices run from a money perspective, how you finance your cases, whether you have a client who's advancing costs, whether you are advancing the costs. When you do class action work, typically the attorneys that are representing the class are advancing the costs. That's a pretty significant financial outlay from year to year. I mean, as an example, a case that Marcy was talking about, we represented 40,000 class members nationally. It was a consumer class action against a series of banks and tax preparers. And that case we litigated for 6 years because it went up to the Court of Appeal and came back before we settled it. And I think the costs in the case were $150,000. So that's out of pocket from the law firms. And we were co-counseling with a nonprofit, so we advanced all those costs. So it's there are a lot of learning a lot of the economics, which I hadn't anticipated and wasn't thinking about as a lawyer.
Okay, any other questions for Monique, and we'll move on. Now we'll move on to let's hear about big firm practice.
I don't think that'll be a problem. Well, like the other panelists here, when I went into law school, I knew that labor and employment law is really where I wanted to practice, and I think that kind of grew out of my dad. My dad was a manager for many years, and he often told me about the training and all of the things that they did to comply with state law in Washington, which is where I grew up, and also, collective bargaining and all that encompassed. So when I went to college, I did an internship with the City of South Bend Human Resources Department. And that was a real interesting experience, seeing from a municipal end how you deal with people, what issues arise, both in the union context and in the non-union context. And just so happened that after my senior year of college, I was already going to go to law school. I went straight from undergrad to law school. I was working at a beef plant in Toppenish, Washington, where the employees went on a wildcat strike, which is an unauthorized strike where the employees walk out of the job without the authorization of the union. So it was an interesting conflict because this was not a situation where the union and the employer were at odds. It was